Thank you. Is that? I can't tell. Okay. Thank you so much. Thank you for having me here. Thank you to Pella and the Ecocide group and Loden as well, which have invited me here, my organization here, to participate at the Earth Rights Conference last week, over the weekend, and the different meetings that we've been having over these few days. We were in Uppsala yesterday, which I learned is not Uppsala, but is Uppsala. I was happy a lot. Yeah, you're all laughing at me because everyone laughs at me about that. We've had a good opportunity, I think, to meet and discuss this concept of the rights of nature with a lot of different people. This morning we were over at Parliament. We met with some members of the Green Party to discuss what the rights of nature is, why people are advancing the rights of nature in different countries. I think it was a very, very good conversation, and I think it's quite pleased that we could be here this afternoon as well. So just very briefly, I work for an organization, and if you have the handout, you'll see, the Community Environmental Legal Defense Fund, and I head up our International Center for the Rights of Nature. We are an environmental NGO, and we're based in the United States. So we now work outside of the United States as well. We began as a very conventional environmental NGO with the purpose of helping people and communities protect the environment from particular environmental threats. In the United States, as you may know, for example, we have a great deal of fracking happening. And so we have work with a number of communities that are trying to stop fracking from coming into their community for all of the reasons we can discuss. But we started out in 1995 as very conventional, and what I mean by that is, like other environmental organizations, we focused on trying to better regulate activities, like mining or drilling or factory farms, which we have a great deal of in the United States. And we tried to do the work of what we call stopping permits or permissions that are given by government to industry, to corporations to conduct certain activities. And what we went through a very long learning process in that we discovered that it was very difficult to stop the government from issuing permission or issuing a permit to a corporation. Is there feedback? Oh, I did, sorry. Yeah.
Don't be too close to your brother.
I know. I'll tell him. So what we learned was that because environmental laws issue permissions or permits to corporations to conduct any number of kind of activities, we learned that environmental laws actually legalize environmental harm. So they legalize fracking, they legalize mining, they legalize factory farms, they legalize the privatization of water sources, they legalize all sorts of kinds of practices that communities and people are trying to stop because they are harming the environment. And when we move from that understanding to, that environmental laws not only legalize these kinds of activities, essentially they're based on this premise that we as human beings have the ability to use nature to suit our needs, to benefit humankind. And indeed, our laws reflect this, because our laws treat nature as property under the law. Or as a commodity under the law, which means that environmental laws regulate our use of that property, our use of nature, which makes sense if our environmental laws, which we think are about protecting the environment, when in fact environmental laws are regulating how humans use the environment. So that means that it's treated as property under the law. Nature is considered rightless. It has no right to exist. It has no right to flourish or regenerate or to evolve. And that's thousands of years of history now that legal systems treat nature as property. And as a result of that, we've had our major environmental laws in the United States and laws which are now mirrored in countries around the world. These laws have been put in place now for 40, 50 years, and we can see the consequences of it very clearly. Climate change accelerating, species extinction accelerating, ecosystem collapse accelerating under environmental laws that are in place all over the world. And the question is, well, why? Why don't environmental laws work? Well, through our work in the US, we discovered that environmental laws don't work when we treat nature as property. Environmental laws don't work because they were never written to protect the environment. I'll say that again. Environmental laws were not written to protect the environment. Environmental laws were written to regulate human use of the environment. And that's a difficult concept sometimes for us to get our minds around. It took us a while to understand that. It took us a while to understand that environmental laws reflect larger legal systems. Larger legal systems in the United States and around the world are primarily focused on how do we continually have more growth, more development, more production, more extraction. The primary aim of governmental systems, legal systems around the world is how do we continue that constant development, constant human development. And to fund that, to provide for that, our environmental laws necessarily have to regulate how quickly we can take the raw materials out of nature that we need to fund that constant growth. So we went through a process to understand how not only do environmental laws regulate human use of nature, but also that larger legal systems protect that, insulate that, and champion that in order to advance the power, to grow the power of a nation, to grow the economy of a nation. And that was a process that came to us to understand that it's not that our environmental laws aren't strong enough, that we need to try to better regulate fracking or better regulate mining, because by regulating them, we're allowing them to happen. And our communities and people don't want them at all. They understand that those kinds of activities are inherently incompatible with protection of the natural world. And under these legal systems and environmental laws around the world, we see that the very fabric of life is now at risk. We see the collapse of the living systems that we all need in order to survive. Things are getting very, very dire. And perhaps you wouldn't be here if you didn't think so as well. So that took us on a journey of understanding about how existing legal systems work. And we looked at what did other movements do, other past movements of people do when they came up against a legal system, an economy, and a culture that they considered to be destructive or oppressive or perhaps unjust or illegitimate. What did other movements have to do in order to fundamentally change how governing and law occurred? So we looked at movements like the abolitionist movement in the United States, which worked to end slavery and recognize rights of the freed slaves. Our Constitution codified slavery, and so they had to attack the very basic structure of law. Suffragists, and some of the folks in this room have heard me say this a few times already, but it was very interesting for me. Before I came here, not only was I looking and reading the environmental code, I was very interested to understand, what do past movements look like here in Sweden? What kind of history do you have? Is it similar to our experience in the United States? And indeed it is, there are similarities. So the suffragist movement here in Sweden spent generations advocating for the right of women to vote. And it began at the local level, and ultimately in the 1920s, much like in the United States, that women secured the right to vote at the national level. And what did those movements have to do? Well, those movements had to understand that the problem they faced was systemic. It was based in the structure of law itself. And today we have a systemic problem. It's not that we want to regulate factory farms better, or regulate fracking better, or mining better, or other kinds of activities like that. It's the system of law itself which is the problem. Systems of law which are based on constant growth and expansion. And that, it's a systemic problem. And understanding that, we had to reframe, re-understand, learn anew what the problem we faced was as an environmental group. And so we finally came to a place where we understood we need to, if we're going to attack a systemic problem, we need to ourselves be advocating for systemic change. So like past movements, the abolitionists weren't trying to regulate the practice of slavery better. They didn't want to see improved slave codes, which is what our laws were that regulated how slavery could occur. They wanted to end it altogether. Women weren't trying to have better improve their situation under a structure of law that didn't recognize them as having rights. They wanted to change that system altogether. And so they had to address the structure itself. And that's where we are today. Slaves were treated as property under the law. Women were treated as property under the law. Today, legal systems treat nature as property under the law. And much like those past movements had to transform that which was treated as property under the law to being rights-bearing, Today, nature, similarly, we are seeing a need to transfer it from being property under the law to being rights-bearing. And that's the work, the journey that we began a little over 10 years ago now, in which we began working with the very first communities in the United States to recognize inherent rights of nature. So some of you have the handout. In 2006, we assisted the first community in the United States. It's called Tamaqua Borough. We assisted them to draft the first law in the United States, as well as in the world, that recognized the rights of nature in binding law. That recognized a right to exist for nature, a right to flourish, a right to restoration and regeneration. Today, we now have dozens of communities across 10 states in my country that have established that nature has a right to exist and flourish within binding law, and that people and their governments have the legal authority to essentially stand in the shoes of nature to defend and enforce those rights on behalf of nature. Back in 2008, as this work was really just beginning in the United States, Ecuador was drafting a new constitution, and we were invited into Ecuador to meet with their constituent assembly, which was essentially that constitutional convention, if you will, that delegates brought together to draft the new constitution. We met with them, and long story short, we worked with them to draft provisions to recognize the rights of nature, to enshrine it within their new constitution. And indeed, in 2008, they promulgated their new constitution, making Ecuador the first country in the world to enshrine constitutional rights of nature. And the question is why? Why are we doing this? Well, it's about advancing systemic change. It also comes with an understanding that so long as nature is treated as solely existing for human use, well, the consequences of that are very clear. Environmental systems are declining around the world. In Ecuador, within their constitution, they have secured a human right to a healthy environment. Now, I think it's somewhere upwards of 90 countries around the world have a human right to a healthy environment in law. But what's become increasingly clear is that we cannot fulfill or exercise our right to a healthy environment if the environment itself does not have recognized rights. So this work is building. And in places like India, where we've been working for a number of years, you might be familiar with the Ganges River, which is a very polluted, very denigrated ecosystem. There was a case that was decided in March, so just 3 or 4 weeks ago, in which the court, a high court in the state of Uttarakhand, the court found that because of just how grave the situation there, the court wrote that the very existence of the river is at stake. Because of how the situation of the river being so polluted, they went so far as to say that legal personality, recognizing it for the river within that state, that the Ganges has legal personality with certain rights. They felt they needed to take that extraordinary measure to transform how nature is treated under the law in order to protect and conserve and restore that river system. So we're beginning to see not only direct making of law at the national level, at the local level, but also courts now beginning to move in this direction as well. We've worked as well in places like Ghana and Colombia. We're working in Australia. You may be familiar with the Great Barrier Reef. This was just in the news a few weeks ago. They're finding that hundreds of kilometers, maybe more, thousands of kilometers of the Great Barrier Reef are experiencing die-off and bleaching, much like coral reefs around the world. Well, coral reefs provide habitat for upwards of 9 million species, and they're dying around the world, and that's going to have grave consequences for the natural world. And so we're now working with groups in Australia to begin campaigns to recognize rights of the Great Barrier Reef. I mentioned in India this High Court decision. We've been working there on national legislation to recognize rights of the Ganges River, which we've presented to Prime Minister Modi's government, and they're now taking it into consideration, boosted by that state court decision from a few weeks ago. That this need to transform humankind's relationship with the natural world is essential, not only to our own survival, but the survival of the natural world. We're working in other places as well. So as we were talking with the Green Party members just an hour or so ago, I was sharing with them that last year we worked with the Green Party of England and Wales to draft a new policy platform on the rights of nature, which lays out why rights of nature and then calls for new laws within the UK to recognize that nature has rights and that we need to enforce these rights. We're working in other countries as well. And what's really interesting, when you're at the beginning of a new movement, it's unpredictable how it's going to move forward. None of these things ever move in a straight line. But what we've seen happen now in places like Ecuador, which has it in the Constitution, and Bolivia now has a national rights of nature, what they call the law of the rights of Mother Earth. In Ecuador, we've had the first cases go all the way up to the Constitutional Court, in which people are bringing cases in the name of, on behalf of ecosystems to defend and enforce their own rights. So the first case that was decided in 2011 was for the Vilcabamba River, which was being impacted by government road construction, interfering with the natural flow of the river and putting debris and other things into the river, which was impacting that ecosystem. People brought a case in the name of the river. So the river was the party in the case, bringing a case to defend and enforce its own rights, saying that its rights were being violated by the government road construction. And the court ultimately agreed, affirming that nature has constitutional rights and requiring certain instructions as to how the government needed to restore and change its behavior toward the river ecosystem. We've had other cases now in Ecuador as well, in which the courts find that nature not only has constitutional rights, but that those rights are what the court described as transversal, meaning that the rights of nature within the Constitution affect other rights in the Constitution. So within the Constitution, as I said, they have a constitutional right, a human right to a healthy environment. They have a human right to water. The court said that essentially that because the rights of nature are transversal, they impact those rights. And of course they impact those rights, because I can't fulfill my human right to water if water ecosystems are damaged and polluted. I can't fulfill my human right to a healthy environment if the environment itself doesn't have a similar level of protection. And so we're seeing the development of this, the evolution of this in Ecuador. We have a case now in the United States where we have an oil and gas company is seeking to put frack wastewater and wells into the community to dump that toxic waste within the community. My organization, our legal team, is representing the Crystal Spring watershed there. This is a place called Highland Township in western Pennsylvania in that state, seeking to intervene into this lawsuit because the corporation is saying it has a right to dump frack waste into the community, and the watershed saying we have a right to not have frack waste dumped inside our ecosystems. And so you have this beginning to evolve within the law, within the courts, and more people are taking this up. And so, as we continue this work, we were really pleased to be able to come here. You may be familiar that I think it was 2014, 2015, some of the members of the Green Party, some of whom actually that we met with today, introduced a motion into the Riksdag I think it was called forming a committee or a commission to look at Swedish law and how we could incorporate the rights of nature into Swedish law. And so we had some conversation about that today. I mean, there's already been a little bit of movement here in Sweden. And we talked about what strategies we might take going forward. I think the conference this weekend, the Earth Rights Conference, was another important step forward for raising awareness about rights of nature. And believe me, I understand Sweden has a strong reputation as an environmental leader. And we think that this is an opportunity perhaps for Sweden to become an environmental leader once again, perhaps becoming the first country in Europe to recognize the rights of nature into law. That would be an extraordinary step forward to really transform how nature is treated under the law, transform our human relationship with nature, because what we learned in looking at past movements and learning from our own history in the United States and me learning about the suffrage movement here in Sweden is that the kind of shift that we need, the kind of transformation that we need, if human beings are going to continue to occupy this planet, that we need a fundamental shift, not only in how you and I behave, whether we drive a hybrid car or we recycle or we ride a bicycle. It needs much more than that. It's not only a mind shift that we need, a shift in our culture toward nature. We need to drive that change into law. So like past movements, with the abolitionists, it wasn't that they just wanted people to treat their slaves a little bit better. That wasn't enough. They needed to end slavery, free the slaves, and recognize them as having inherent rights of their own. Today, it's not enough for us to try to be nicer to nature. We need to fundamentally shift our relationship with nature. And that means not only how we think about nature, but how we govern our own behavior toward nature. And for us, that means transforming how the law treats nature from being property to being rights-bearing in its own right. And empowering necessarily people and government to defend and enforce those rights. To us, that is the direction that this work needs to go. It's building in the United States, Ecuador, other countries, and hopefully we'll see some of that moving forward in Sweden as well. Thank you.